The first attempt to create a Supreme Court in Canada failed when a bill proposing it was defeated in the House of Commons in 1869. The following year, a second bill also failed to pass. It would take another 5 years before the Supreme Court of Canada was finally created on April 8, 1875. The new Supreme Court was not technically the top court in the land, it was more of a general court of appeal. Decisions by this court could be appealed to the Judicial Committee of the Privy Council in the United Kingdom. The first Chief Justice, William Buell Richards, was appointed by Prime Minister Alexander Mackenzie. Richards was sworn in on October 8, 1875. The following month, 5 puisne justices joined him on the bench. Richards was criticized by conservatives and liberals alike for the cost to operate the court, estimated to be from $80,000 to $100,000, roughly $2 to $3 million today. Decisions were slow. Justices heard 47 appeals in their first sitting and had delivered only 13 judgments at the start of the second sitting in June 1878. The court delivers approximately 3 times those judgments today. January 17, 1876 was the court's first sitting day, but it could hardly be considered a historic day. There were no cases. Transcripts state, there being no business to dispose of, the court rose. Beverly McLaughlin is a former Chief Justice of the Supreme Court.
It was a very, very unbusy court. They had very few cases. The Supreme Court Act had been passed, but a lot of people thought, we don't really need a court because we have England, we have the Judicial Committee of the Privy Council, and we have our provincial trial and appellate court. So the first Supreme Court of Canada was a court with a role, with a mission to find a role, really.
The early court was composed of 6 judges. Jim Phillips is a legal historian and professor at the University of Toronto.
Sir Samuel Henry Strong, who was the third Chief Justice, was known to be incredibly irritable and cantankerous and rude to people, including many of the other judges. So there are other problems. Some judges were simply too old to do the job properly anymore, and there was no retirement age.
In January 1877, the court finally began holding regular sessions on Parliament Hill. Frank Iacobucci sat on the Supreme Court from 1991 until 2004.
It was not a great court, to be blunt, because they were all friends of the appointing authority and not necessarily the best candidates for the job, so to speak. That's an inside baseball kind of comment, in that they were not the best. In fact, Henry, a guy named Henry, Justice Henry, sat as an exchequer court. 3 of his decisions were appealed to the Supreme Court, on which he sat, which is unheard of in today's world, of course. And he was overruled in 3 cases, and he still voted for his own decision in that court. So it was not the time of history where excellence shone.
In 1927, a 7th justice was added to the court to avoid an even split, and in 1949, 2 more judges were added to reach its present total of 9. In 1929, the all-male court was overruled by England in the landmark Persons case. Legal scholar, author, and professor Constance Backhouse.
In order to be appointed to the Senate, you had to be a person, and they rejected women's request for female appointees. And so the case was appealed to the Privy Council in 1929, and the Privy Council passed this, or they made a lovely decision in which they said the Constitution is like a living tree. It has to amend and expand itself in keeping with the needs of a changing society. And they said, in fact, women are persons. So we got the famous persons case from the Privy Council and not from the Supreme Court of Canada.
The court itself moved to a new small sandstone building at the foot of Parliament Hill, which housed the Supreme Court for over 6 decades. In 1938, construction began on the court's present building. Renowned French-Canadian architect Ernest Cormier was commissioned to create the design. The Art Deco structure, with its chateau-like peaked roof, is a symbol of justice in Canada. The Queen Consort, and later mother to Queen Elizabeth, laid the cornerstone in May 1939, with a speech that may be one of the most feminist speeches ever given by a royal.
It is not inappropriate that this task should be performed by a woman. For a woman's position in civilized society has depended upon the grace of law.
These remarks from the Queen Consort were remarkable at the time for 2 reasons. The first being the reference to a woman's position in society, and the second because such a ceremonial role was typically performed by men at the time.
Finally, in 1949, Canada became of age, juridically speaking, by abolishing all appeals to the Privy Council. And part of that was the growing independence.
The court moved into its present-day location and became the highest court in the land, as all appeals would now be heard at the Supreme Court.
Most people who write about it in that period say that it was a relatively dull court, and it was not innovative. It tended to simply follow established precedent. It didn't see its job as being to change the law to advance a particularly Canadian version of the common law. Followed a lot of English precedent. So not controversial, it became more professional.
Kent Roach is a criminal law expert and was a law clerk for former Supreme Court Justice Bertha Wilson.
Before the Charter, I think the Supreme Court's finest moments were in the 1950s, where in a series of cases, it stood up to the religious authoritarianism of the Duplessis regime in Quebec. And it did things like award damages to Jehovah Witnesses who had their religious meetings broken up by, police, Quebec police, often violently. That, to me, is what the court should do.
I, Michael J. Moldaver.
Michael Moldaver served as a judge on the Supreme Court from 2011 to 2022.
First of all, prior to the Charter coming in, the court had very limited constitutional authority to strike down legislation that was duly enacted by Parliament or the legislatures. And people, and I'm thinking primarily of minority groups, before the Charter, really didn't have any recourse to the courts if they felt that there was a piece of legislation that discriminated against them, or no legislation that they thought they should be entitled to.
While the outside of the Supreme Court was beginning to look different, with the addition of 2 bronze statues designed by Toronto artist Walter Allward, Veritas Truth holding a book, and Justitia Justice holding a partially hidden sword, inside the court was undergoing a transformation.
I would actually say there were 2 moments of important change. One was the 1970s, and particularly the appointment of Bora Laskin as the first Jewish judge on the court, and secondly the appointment of Laskin as the Chief Justice. And Laskin was what you might call a modernist judge. He actually believed in trying to advance the law, change it, make it adapt to contemporary circumstances.
The Constitution is now home.
What many legal historians and experts credit as being the biggest change for the court is the patriation of the Constitution and the adoption of the Charter of Rights and Freedoms in 1982.
And now we had a Bill of Rights that was constitutionally entrenched. And this meant that courts across the country, for the most part, some courts not, but most of the courts across the country could now strike down legislation and/or laws that failed to conform with the guarantees that are included in the Charter of Rights, the guaranteed rights and freedoms.
So now I think what you see is a court that really has an expertise on public law, including criminal law. So that's the staple. And then you also have a court that, although not nearly as famous as the United States Supreme Court, and that might be a good thing, but is much, much more in the public eye.
As the Supreme Court celebrates 150 years, it is planning for the future. In 2026, it will move into the West Memorial Building as the present courthouse undergoes extensive renovations. Coming up in our next episodes, we bring you more on the role of the court.
It has a role that's somewhat like a parent. That, when parties are disagreeing or have a significant conflict, someone has to render a decision. And so that's largely what our Supreme Court does in our system of government.
Its inner workings.
The court needs as much as possible consensus because the consensus gives clarity. The rest of the country is taking its lead from the decisions of the court.
And why judicial independence is of critical importance.
Courts have to be impartial, and for that reason they have to be completely independent of these other branches of government and seen to be independent.
All that on the next installments of CPAC's Inside the Supreme Court of Canada, 150 years of the highest court in the land.